Mr. Miller.
Before I return to the Guardian case, two clarifications, if I may, from yesterday. First of all, Lord Reid raised the content of the reporting with me yesterday, what would be in the reporting, and I just wanted to make clear that as far as any reporting of the civil proceedings, these proceedings, is concerned, they were heard in private with an anonymised judgment, as you know, and there has been agreement that much of the material that you see in the witness statements on the appellant side is to be regarded as confidential. So there are redacted versions, agreed redacted versions of those statements. So don't assume that everything you see in those witness statements would end up being reported, far from it. The other point is Lord Wilson's point about paragraph 80 in Mr. Justice Tugendhat's judgment at page 137. My Lord asked, why did he say in my judgment I'm bound by the decision in Ries? We think the answer lies in the submission made by my learned friend, which is recorded back at paragraph 62 in the judgment on page 131. He was contending that there was an aspect of Ries which was no longer good law. And if you read 62, I won't take time over it now, but if you read 62 and the whole of 80, it is tolerably clear that what Mr. Justice Tugendhat is doing at 80 is dealing with that submission. So to return to the Guardian, I'll take it relatively shortly as the case is well known, simply dealing with the passages we rely on and the points that we take from them. At page 585 in the bundle, as I mentioned yesterday, the court, this court, paragraph 30 in the judgment, identified, Lord Rogers speaking for the court, the jurisdiction to make privacy injunctions against the press to protect Article 8 by reference to the Ries case. More importantly, at 52 on page 590, Lord Roger identified, this is the bottom of page 590, a report of the civil proceedings identifying M, the claimant whose case was an issue, as a matter of general public interest. And drawing a number of threads together from the earlier cases which he had reviewed, he formulated the issue in the Guardian case, in this court reporting case, as whether there is sufficient general public interest in publishing a report of the proceedings which identifies M to justify any resulting curtailment of his right and the family's right to respect for their private and family life. And that was the basis on which the Court of Appeal approached the issues in this case, that passage. And I'll just give you the reference. It's paragraph 29 in the Court of Appeal's judgment at page 110. At paragraph 58 on page 592, Lord Roger returned to the case advanced by M, which we looked at yesterday in paragraph 21 of the judgment, and said this: it's more of a comment than a criticism to point out this evidence is somewhat speculative. Moreover, the impact of the publication of M's name is particularly hard for a court to judge when it does not know how he is currently regarded by other members of the community. And we say there are similar, though obviously not identical, issues in this case. The court deciding the case has to measure the impact of the postulated report on the Article 8 rights of the claimant, and that's not easy to do. And I emphasize again, as I did yesterday, that the report will stress that the applicant has been de-arrested because of insufficient evidence.
But why is it necessary to name him in order to make the report that you propose?
Well, the question is, with respect, not the right one. It's not a question of whether it's necessary to name him, as we shall see from the passages we're about to come to.
Well, it may not be the right question, but would you mind answering it in the meantime?
Why is there an editorial decision to name him?
Yeah.
Because for all the reasons that were identified in Ries and that are discussed by Lord Roger in The Guardian, the Guardian case.
No, those have universal application.
They're not of universal application, no. The position of both newspapers is that a report of the sort that's postulated will be of greater interest to their readers, will be given greater prominence in the newspaper if it's possible to identify the people involved. That is an editorial judgment. And it is a proposition that we advance, as advanced in Re-S, that if newspapers are faced with a situation where they have to write court reports not identifying people and not naming people, there will be less court reporting and there will be less paragraphs of court reporting.
Yeah, but I just have some difficulty in identifying the intrinsic value of naming a person if you're simply seeking to establish that the constraints that are introduced by Section 4, subsection 2, are an inhibition on free reporting of court proceedings.
Well, they're already an inhibition from the point of view of contempt law at the time the order is in place. The argument under Article 10 is that the full story can get told. Could I come back to that?
Yes, by all means.
The two passages.
Yes, by all means.
Because there is law dealing with this point.
And as I understand it, you're not simply focusing on publication of, as it were, the Section 4.2 saga. You're talking also about publication of an accurate report of the proceedings at the trial. Am I right?
Yes, it will report the content of the 4.2 application. So it will report the evidence and the parts of the trial that were the reporting of which were postponed.
Yes.
The reasons why an argument was put forward for postponing them, the reasons why they were postponed, and what has happened since.
Yes.
So the whole tale will be told.
Yes. So if there is an intrinsic interest in the reporting to the public of proceedings at a trial, then the evidence given and submissions made and so forth relating to the appellant are part of the trial proceedings.
They are, yes. And the added twist in this case, as I said yesterday, is that he was able to send lawyers on a number of occasions to try and prevent the contemporaneous reporting of that evidence. The question of who it is who's doing that is of importance.
Mr. Miller, I'm terribly sorry. I haven't quite understood the ambit of the proposed publication beyond the Section 4.2 saga.
There isn't an ambit beyond that, but the Section 4.2 saga involves reporting everything that was debated in the Section 4.2 proceedings. So what were the parts of the trial that he was seeking to postpone reporting of? And then, of course, what are the parts of the trial in the subsequent civil proceedings that he would be preventing reporting of if he got his injunction? So
effectively, all the material that might be relevant to the article from the original court proceedings will, via the 4.2 application, come in. But as I understand it, some of that material was known apart from the criminal proceedings, in particular the fact of the arrest.
correct. In fact, a lot more of it was known apart from the criminal proceedings.
Right. Well, that's
So not everything that is... I'm sorry to interrupt.
what was known apart from the criminal proceedings. The only thing I've seen in the papers is the fact of the arrest.
It's the points in the two May emails that were sent to the appellant,
Yes.
Mr. Wilkinson and the Times.
I mean, for instance, the identity parade, that was, as I understand it, derived exclusively from the evidence given in the criminal proceedings.
I can't say that. I mean, journalists have sources for all kinds of information about police investigations.
So we don't know entirely.
No, but I'm not for a moment pretending that the investigations by the journalists that were behind the May emails were not more extensive than those emails suggest. But the key point is the content of the proposed article is circumscribed by Section 14 of the Defamation Act and the need to present it as a fair and accurate report of the events at the Crown Court trial. So page 592, we rely on all of paragraphs 59 to 62 in this section, which is regarding the Article 8 arguments in favour of an anonymity order. We won't read these in full, but they're important, and essentially the court proceeded on the basis that, faced with a fair court report of the Treasury's claim that it had reasonable grounds to suspect M of terrorism, readers would be capable of drawing the distinction between mere suspicion and sufficient evidence to prove guilt.
Yes, well, that is paragraph 66. The law proceeds. Now, of course, the House of Lords is, or was it the Supreme Court? It was the Supreme Court. The Supreme Court is perfectly entitled to say the law proceeds for itself without any previous authority to that effect. But was there previous authority to the effect that the law so proceeds?
I'm so sorry. I think. Could I come to that, paragraph 66 in a moment?
Do.
I think what the court is saying here, which is at 60, at the top of 593, is what it is saying is we can see no reason to assume that most members of the local Muslim community would be unable to draw the necessary distinction. So that is in effect a finding of fact by this court, its conclusion, on which it's deciding whether to lift the anonymity or not. It's a finding of fact as we understand it, specific to this case. And what Lord Roger went on to say for the court was that this being so, perhaps the main argument against discharging the orders was that in the civil proceedings, M was unable to challenge the substance of the allegation against him. And you'll see that at 61 and 62 on the same page. We also rely, and I'll come to it now, on 63 to 66 at page 593 over to 594 and paragraph 73. This is in the section, the arguments against an anonymity order. Again, I won't read these in full, but to summarise, the court at 63 in the well-known "What's in a Name" passage recognised the importance of allowing journalists to refer to the identities of those involved in court proceedings and in court reporting as part and parcel of discussing the issues raised by the court in the proceedings. I won't read through the whole paragraph. It's a very familiar paragraph. It begins with that. Stories about particular individuals are simply much more attractive to readers than stories about unidentifiable people, and so on. And he cites, in the middle of the paragraph, Lord Hope of Craighead in the BBC case, paragraph 25, which I'll come to in a moment when I deal with the presumption of innocence. But these passages, 63 in The Guardian and Lord Hope's comments at paragraph 25 in the BBC case, emphasise the importance of retaining an Article 10 right for the journalist and the editor to determine the form that the report takes, including detail in their editorial judgment, both to make it interesting to readers and to corroborate the substance of the story, to give facts, sufficient facts, to ensure that the point of the story is got across. And we would say that by the time you've considered those principles in those two passages, you will appreciate that Mr. Barker's suggestion in the oral submissions yesterday that our desire to identify PNM in the report by reference to what was said about him at the Crown Court trial is nothing more than a desire simply to add a bit of colour, I think, is what he put in his oral submissions. It is something more than that, because what's discussed about him will be discussed about him in the report will explain the context in which the 4.2 application was made, who was making it, why he was able to make it, and what the importance and consequence of the application was. Stripping out identifying detail relating to PNM will be a disembodied account of the Section 4.2 saga. It will make it more difficult to understand and less interesting to an editor to publish and less interesting to a reader to read.
Do you support or adopt the really quite extreme statement in the last sentence of paragraph 63, that not allowing basically the print media to identify people involved in criminal trials will mean, might threaten the viability of newspapers and magazines? It's quite a strong statement.
Yeah, that is a strong statement. I think what we would prefer to say is what Lord Steyn said in Ries, which is that if court reports have to be written in this way, it threatens it threatens court reporting. That court reporting without sufficient detail will not be included in newspapers and will not be read by readers in the same way if it is, and that has a very general implication in our democracy because of the importance of court reporting, particularly by local papers, in relation to the rule of law and getting across to the public in broad terms what's going on in criminal courts. I think it would be fair to say that there are other threats to the viability of newspapers, these not least of all the internet.
That was slightly behind my question.
Yes, I mean it's a very, very complex area. So we would prefer to put it that way. We also rely on 66, which is the very well-known passage that the Lord was referring to. And again, I won't read it because we've seen it before. What it in fact says is that it's a comment, it seems to us, about the issue we were debating yesterday, which is the law allowing, in criminal proceedings, allowing identification of persons after they've been charged. So in your first production at the magistrate's court in this country, you can be identified by name. You charge, you're brought before the magistrate court. You can be identified by name. It's not necessarily the case in other European countries. So he says the identities of persons charged with offences are published, even though their trial may be many months off. In allowing this, the law proceeds on the basis that most members of the public understand, etc. That, in fact, that's really a comment about, it's a much more general comment about the policy of the law in this area in our country, including the law of contempt. Is there a risk to the fairness of the trial and so on and so forth if you identify the defendant early? There are no doubt other factors.
Is that, I mean, that sentence, the judge appears to have regarded that as a proposition of law in paragraph, I think, 77.
Well, with respect, we don't agree. We think 77 is a finding of fact because he says that's the basis on which I approach the case.
Well, the difficulty about that is that paragraph 77 refers back as the reason for the approach adopted to paragraph 65, which contains nothing other than the statement from paragraph 66 of Guardian News. Moreover, in the two previous paragraphs, he has said that he accepts much of the evidence of the claimants and certain of his submissions. He then comes in effectively saying, nevertheless, I approach this case on the footing set out in paragraph 65. He appears to there to be saying, well, whatever the concerns and the facts may be, the law proceeds upon this basis, whether true or false.
We simply don't agree. I mean, we have to defend what the judge seems to be saying here. It seems to us quite clear. He is saying in 75, there is some risk. He accepts there is some risk of an article being read that way. But what he is saying at 77 is what he thinks the position will be generally when people read this article. There is absolutely no inconsistency between saying that. There is some risk that some people will do that.
It's not quite the point that's being put to you.
No, I understand that.
What's being put to you is that by tying it into paragraph 65, the statement in paragraph 77 is based on the proposition that what is said in Guardian News and Media in paragraph 66 represents the legal position he must adopt. Otherwise, why refer back to 65?
Well, it depends what he means by on the footing set out. I mean, what is advanced at 65, what is advanced in Lord Roger's speech at 66 is a proposition about why we allow reporting of people who are charged, but it is also a proposition, a more general proposition, about what most members of the public will understand.
Well, given that Lord Roger says in that passage, the law proceeds on the basis that.
Yes, in relation to allowing people who are charged to be identified.
No. If you look at the fifth or sixth line of the quotation in paragraph 65, and allowing this, the law proceeds on the basis that most members of the public understand. And it seems to me...
This is the identities of people charged with offences being published. That's what this is.
But he then goes on and says that understanding can be expected to apply a fortiori if you were someone whom the prosecuting authorities are not even in a position to charge and bring it to court.
Exactly, but it's all governed by the law proceeds on the basis.
Well, I'm not, with respect, I'm not sure that's right. I think that's the way into the understanding. It's the way into a factual understanding. What he's saying is, this is the factual understanding, and it's the basis on which our law proceeds in relation to charging decisions and the charging of people. Yeah. What he's saying is, as a matter of fact, it's an even stronger understanding of how people read articles when you're not even saying they've been charged, when you're saying they're merely suspected of an offence.
At any rate, I infer from those answers that you don't submit that it's a proposition of law. You don't submit that there is a rule of law or a presumption of law to the effect that the public are assumed to understand the difference between an accusation and proof.
No, but not in this context. But there is, in the context of contempt, and how in our court system you allow the reporting of criminal proceedings where somebody has been charged, which is what he's talking about at the beginning of the sentence. As I say, that is a rule of law, and it's not one that applies in all European countries. In other European countries, from the point of charge onward, when you're brought before the court, you may be anonymised or the proceedings may be in private, and there may be variations on that. The position of our law, this is what he is saying, is different at that point and in relation to that. And he's looking at why that is the position our law takes.
Anyway,
I think you kindly said you'd come back to my question, which was when Lord Roger says the law proceeds on the basis. He was perfectly entitled to introduce this for the first time, but was there any previous jurisprudence indicating that the law did proceed on that basis?
In this context? In this context of 8 verses 10 and press report?
Yes.
No, I don't think there was.
Or any other context?
I mean, I should say, we need to come to the INRI BBC case, because INRI BBC, the BBC was proposing to identify an acquitted person in a documentary, and that was the Article 8 verses 10 dispute. So there is some law on the press doing that, and the freedom of the press to do that.
It occurs to me that what Lord Roger said about this in the Guardian case is actually rather similar to what he'd said in a number of judgments when he was Lord Justice General in Scotland, which were concerned with prejudicial pre-trial publicity, where a defendant was saying, "I cannot receive a fair trial because of pre-trial publicity," and he developed quite a strong line in cases of that kind that really, as a matter of law, the court is not going to discharge defendants on that footing in the absence of extreme circumstances because of a strong presumption that members of a jury, members of the public, will take what they read in newspapers with a pinch of salt and be able to distinguish between allegations and guilt.
Exactly.
But the two contexts are quite different, of course. If someone is going to be charged, the judge will adjure the jury to decide the matter on the evidence that is given. If we're looking at the situation where there's a report of someone having been referred to in the trial as having committed offences, he doesn't have the benefit of that adjuration. And whether or not, when one is addressing the question, whether contempt proceedings should succeed on the basis that it is to be assumed that the jury will not be swayed unduly by press reporting, I don't think it necessarily follows that the members of the public will likewise apply that discriminatory approach to a report that someone has been accused in the course of the proceedings of being guilty of an offence.
Well, there is a lot of case law on that, in particular under Section 4.2, including some Scottish cases that are important and interesting, where the issue arises about comment in newspaper articles, going beyond the fact of the person merely being charged and being brought to trial. There is an argument about that, but my point is simply that I keep saying I'm defending Lord Roger. He was speaking for the court. I'm defending what the court said in The Guardian. It seems to us that he is simply putting a proposition about why in our criminal justice system we allow people who've been charged to be identified publicly, and drawing the distinction between that and mere suspicion. It doesn't seem to us as complicated as perhaps the other side suggests. And the conclusion of the court is, we say, an observation in relation to the facts underlying that piece of law. And then at 73, we rely on 73, which is at page 596. Here we return to the point that we discussed yesterday about what is the weight of the privacy right, where you report on a person having been charged or being suspected of a criminal offence in relation to some aspect of their life outside the family life. And the court said, this is not a situation where the press are wanting to publish a story about some aspect of an individual's private life, whether trivial or significant. Rather, they're being prevented from publishing a complete account of an important public matter involving this particular individual for fear of the incidental effect it would have on M's private and family life. And I'm not minimizing that. I did accept yesterday, following the exchanges with the court, that you can weigh the Article 8 right by reference to the impact the reporting has on private and family life. There's no question about that. The court here is drawing a distinction, though. It's making a different point, which is the content of the reporting is not about private and family life. It's about somebody being caught up in criminal investigations by the state into alleged offences that have nothing to do with their private and family life. And that is an important consideration in the balancing exercise. And we don't resolve from that proposition. So I turn, if I may, to A versus BBC. Again, this was a judgment in May 2014, given after the decision of Mr. Justice Tugendhat. As we know, it was also considered by the Court of Appeal because my learned friend Mr. Barker raised it before the Court of Appeal. And again, I make no apology for emphasising what I call the shape of the case. As I said yesterday, the shape of the Ries case is the High Court preventing the press reporting criminal proceedings elsewhere. This was not a Ries-type injunction case. This was not the High Court doing that. This was a case where the Court of Session had exercised its inherent jurisdiction to control the proceedings before it and allowed an applicant for judicial review to withhold his name, and had exercised the power to give a consequential direction to the media under Section 11 of the Contempt of Court Act, prohibiting the publication of that name in connection with the proceedings. The judicial review concerned proceedings in the first-tier tribunal and upper tribunal. The former, the first-tier tribunal, had anonymised the applicant because his appeal against deportation was based on a risk that in his country of origin, when returned, he would be in physical danger as a sex offender. The appeal was rejected, and he was challenging the refusal of permission to appeal by the upper tribunal. The issue of reporting restrictions ended up in the Inner House because of a challenge by the BBC. And my Lord, Lord Reid, again speaking for the court, emphasised at paragraphs 27 to 35, beginning at page 512. I won't go to these because it's a long passage, but the court emphasised the principle well established both in England and Scotland that the inherent jurisdiction of a court to control the proceedings before it allows it to derogate from open justice in order to achieve the ends of justice, but no more than is strictly necessary for that purpose. At page 515, if we could go to paragraph 38, in the paragraphs 38 and 39, at pages 515 to 516, my Lord reviewed a number of cases illustrating the flexibility and the width of the common law power to derogate by withholding names. And none of this is contentious. There is obviously an infinite variety of situations where the court hearing a case will be concerned that the emergence of an identity in open court will make a party or a witness less confident about participating in the proceedings, or where a refusal to withhold the name will undermine the administration of justice generally, perhaps because it's understood that in later cases, where a similar identification issue arises, a witness or party may be less likely to willingly and confidently participate in the knowledge that the court hasn't withheld the name in the earlier case. And that's a strain of reasoning that you see in some of the Canadian cases that my learned friend has cited, where trial judges in civil actions involving allegations of sexual abuse recognize the implications for such cases in the future if there is not anonymization. There is nothing contentious about any of that. The appellant relies on paragraph 40 at page 516, but which we looked at yesterday. But the observation that the common law in this area will develop and do so with regard to developments in other common law jurisdictions and the ECHR is, with respect, entirely uncontentious. This has been happening ever since Scott versus Scott, with decisions in cases, in individual cases, about courts' conduct of the cases before them, indicating either a new understanding about what openness demands, such as the Westminster Justice's case about access for journalists to court records, or about when a derogation is required. Paragraph 45 at page 518 is specifically about the unqualified rights under Article 2 and 3 of the Convention, but the sentences at the end are more broadly about the obligation of the courts under the Convention to protect Convention rights in appropriate cases and the need to have remedies available for them to do so. Again, this is uncontentious, whether the right concerned is unqualified or qualified, like Article 8, which is dealt with in the next paragraph. 46. So at 48, we then come to the passage which the Court of Appeal understood, this is the bottom of 518, to be agreeing with the approach adopted by the House of Lords in Ries and the Supreme Court in The Guardian. In the judgment of the Court of Appeal, it's the passage at paragraph 39, page 112. And we say this understanding of paragraph 48 by the Court of Appeal was plainly correct. This paragraph is explaining the need to undertake the parallel analysis described by Lord Steyn in Ries in cases where Article 8 comes into conflict with Article 10. Note also, please, at paragraph 55, my Lord, on behalf of the Court, made a point of distinguishing, in the teeth of the submissions by the BBC, the Ries High Court jurisdiction to make injunctions against the media preventing them reporting criminal proceedings to protect convention rights from the very different power involved in withholding a name in open court, which derives from the inherent jurisdiction. This is precisely the distinction we have made repeatedly in the course of these submissions. The appellant also relies in his written case on paragraph 56, which is at page 521. But the suggestion that the common law is in vigour in this area, whilst correct, is entirely non-contentious again and far too general to have any implications for how the Court of Appeal was supposed to approach this case. The appellant also relies in his written case on the observation at 57 regarding Section 6 of the Human Rights Act, and the starting point in domestic cases being the common law open justice principle. But again, this is uncontentious. The Convention jurisprudence accords a margin of appreciation to contracting states. HRA Section 6 has to be applied with this in mind. The first thing a domestic judge must do in a case where convention rights are engaged is always to apply the relevant domestic law. Then test whether the judge's reasoning and the outcome on the domestic law respects the principles established under the relevant Strasbourg case law. If it does not, it may have to be adjusted unless Section 6.2 applies, rendering a non-compliant decision lawful in domestic law. There is absolutely nothing novel about understanding Section 6 like that. The effect of Section 6.1 is a check. It's a check on your reasoning and the outcome you get to under domestic law in a case where a convention right is in play. So to say the starting point is the common law is correct and non-contentious.
Yep.
So to conclude on the first part of our case, we say that A versus BBC accurately restates but does not extend the point the common law has reached. Still less is it an important recalibration of the open justice principle, as the appellant contends. If a court hearing a case finds that the interest demanding the withholding of a piece of information, which may include convention rights in play, is strong enough to justify it doing so, it has an inherent jurisdiction to do so in order to protect the administration of justice, broadly understood. There is then a consequential statutory power under Section 11 to prevent publication of the information withheld. None of that happened in the Central Criminal Court in this case. The Court of Appeal was not concerned with such a case. It wasn't concerned with an A versus BBC case where evidence had been withheld and a consequential direction made under Section 11. Rather, it was faithfully applying Ries in a case which was a Ries case, albeit unusually, where the injunction sought was to prevent reporting of open court proceedings that had already taken place and concluded.
Yeah.
The Court of Appeal also applied the approach in The Guardian. We say there were no errors of approach in Tugendhat J's reasoning, and I've just dealt with this with my Lord Sumption. We see no tension between 75 and 77, and we don't perceive 77 as a misdirection, but rather an explanation as to what his conclusion was on the facts about how the article would be read generally. So I turn to the second half of our case, and I do want to start. So the second half of our case is looking at the appellant's reasons why the Court of Appeal should have developed the common law to make an exception to open justice in this case. I do want to start by looking at the issue of the presumption of innocence. This is relied on as some sort of freestanding consideration which suggests that our common law should be changed in the way suggested by the appellant. It's important on this issue to consider the decision of the House of Lords in the Attorney General's ref of 1999, which I'm calling in re BBC, which is at MS page 528. The BBC wanted to put out a documentary about the acquittal of a man, D, in the case report, he'd been acquitted in 1999 of a rape committed during a burglary. The acquittal was required by a ruling by the Crown Court judge that the Crown's DNA evidence linking him to the offence was inadmissible, and therefore there was a direction to the jury to acquit because it was the only evidence the prosecution had. The postulated programme would suggest that consideration should now be given to a retrial of D pursuant to the provisions of Part 10 of the Criminal Justice Act 2003, allowing a case to be referred back to the Court of Appeal and an acquittal to lead to a retrial on new DNA evidence. The original case had resulted in 1999 in an Attorney General's reference to the Court of Appeal and then further to the House of Lords on a point of law. The House of Lords had made an order, in effect an injunction, preventing D being identified in the media. So this now presented a problem for the BBC years later when they wanted to put out the broadcast. It applied to the House of Lords to discharge the order. The House of Lords did so, carrying out the res balancing exercise. On the presumption of innocence, if your lordships, if the court looks at 22 at page 537, you will see in the opinion of Lord Hope that he, in assessing the Article 8 right in play on D's case, D was not represented. Lord Panic assisted the court as an amicus.
Yep.
He said this at the end of paragraph 22, he, that is D, remains entitled to the presumption of innocence. This is not just an Article 6 point. It has a direct bearing on the approach that must be taken to his Article 8 right. The link that his DNA sample provides to the commission of the rape is personal information. Giving of publicity to the link will inevitably suggest that he is guilty of the offence. Lord Panic described this as the jigsaw effect. His reputation, his personality, the umbrella that protects his personal space from intrusion, will just as inevitably be damaged by it. The conclusion that broadcasting this information will engage his right to respect for private life seems to me inescapable. So the presumption of innocence is understood perfectly straightforwardly to be relevant to the assessment of whether Article 8 is engaged and what the weight of the right is. If the court turns on to page 549 at paragraph 69, in the opinion of Lord Brown, you will see that he agreed with Lord Hope that presumption of innocence was relevant not only under Article 6 but under Article 8 insofar as it bears on the D's reputation. That said, he concluded, for the reasons already given on the particular facts of this case, I find it difficult to regard D's right to his reputation as outweighing that of the BBC to imperil that reputation by their proposed broadcast, a broadcast of undoubted public interest. And of course, this was a case where the BBC were, by definition, not going to stress what we have to stress in our fair and accurate court report, which is the outcome of the investigation into the defendant being his de-arrest and the fact that he hasn't been charged. On the contrary, they were not going to stress the outcome of the proceedings against D, the acquittal in the criminal proceedings, in his favour. They were going to say there were grounds to retry him for the rape. Quite the opposite. Yet still, the broadcast was permitted. The House of Lords, the Judicial Committee also tackled the issue of whether the BBC should be compelled to broadcast its documentary without identifying the defendant. So the submission was made in that case, as has been made in this case and is made in many other court reporting privacy cases. Well, you can publish the same material without identifying the person, and on that basis, the Article 8 right should prevail. It held that the BBC should not be restricted in its reporting in this way. And if we turn back to 25 and 26 in Lord Hope's opinion, at page 538, He said, Lord Panic suggested it would be open to the BBC to raise the issue of general interest without mentioning Dee's name or in any other way disclosing his identity. But I think that Mr. Miller was right when he said the BBC should not be required to restrict the scope of their programme in this way. The freedom of the press to exercise its own judgment in the presentation of journalistic material has been emphasised by the Strasbourg Court. In Jersild versus Denmark, the court said it was not for it, nor the national courts for that matter, to substitute their own views for those of the press as to what technique of reporting should be adopted by journalists. It recalled that Article 10 protects not only the substance of the ideas and information expressed, but also the form in which they are conveyed. In essence, Article 10 leaves it for journalists to decide what details it is necessary to reproduce to ensure credibility. See Freyso-Noir versus France. So the BBC are entitled to say the question whether Dee's identity needs to be disclosed to give weight to the message that the programme is intended to convey is for them to judge. As Lord Hoffman said in Campbell, judges are not newspaper editors. They're not broadcasting editors either. The issue as to where the balance is to be struck between the competing rights must be approached on this basis. And he asked the question, will revealing Dee's identity in connection with the proposed programme pursue a legitimate aim? He considered that it would on the facts. The programme which the BBC wished to broadcast has been inspired by the removal of the double jeopardy rule. What this means in practice for our system of criminal justice is a matter of legitimate public interest. Among the issues which can be so described are the kinds of offences to which Part 10 of the 2003 Act applies, and the circumstances in which it would be appropriate for a person who's been acquitted to be retried would be appropriate. These issues could, of course, be discussed in the abstract by reference to hypothetical facts and circumstances, but the arguments that the programme wishes to present will lose much of their force unless they can be directed to the facts and circumstances of actual cases. The point about Dee's name is that the producers of the programme believe that its disclosure will give added credibility the account which they wish to present. This is a view which they are entitled to adopt, and given the content of the programme as a whole, it is a name which can be properly regarded as legitimate. Now, it's not the same set of facts, but the principles we say are the same. This is the passage referred to by Lord Roger in his What's in a Name analysis in the Guardian case, and it is a very important point of Article 10 law, the need to respect the form and the technique by which the journalist presents the facts and the story to the public in the public interest. We say, coming back to the first point on re-BBC, presumption of innocence, the first of Malone and Friends' freestanding points for saying the law needs to be changed, nothing new there either. It's old hat. The courts have considered the presumption of innocence in the context of Article 8, and it will and can be weighed along with other factors in the way described by Lord Hope and Lord Brown. He then says that the ECHR jurisprudence requires a development of our law, open justice, common law, but there are no developments in the ECHR which point in this direction. He relies on S versus UK, but that's there's a case about vertical application of the convention. It's a case against the state about retention of material. It's not horizontal. It doesn't involve competing qualified convention rights, as is the case when Article 10 comes up against Article 8, and therefore the court was not balancing the asserted rights of private persons. These require a very different approach in Strasbourg, which is that in the Axel Springer case. You were also taken to C versus the Met Police Commissioner, in which the admin court applied this reasoning in S versus K in this country, but it's not relevant for the same reason. It's a vertical application, not a horizontal application case. The appellant also relies on Axel Springer, which is at page 727 in the bundle. And it's an important case. It's the leading authority in Strasbourg on the issues we're looking at in the context of an arrest. It's a Grand Chamber decision, but it does not assist the appellant. The German courts had granted an injunction both on a permanent and interim basis, preventing Bild continuing to publish an article about the arrest of a German TV star for possession of cocaine. As my learned friend mentioned yesterday, there was in issue was a second follow-up article some months later about his conviction. And there was a second set of civil proceedings in which injunctions were granted preventing republication of this article as well. But the one we want to concentrate on is the first article, which was the injunction preventing Bild republishing its article about the arrest of the gentleman at the Munich Beer Festival. The publisher complained of Article 10 violations, and the court found that there were violations in the injunction preventing reporting of his arrest. What the court did is it summarized under 6 broad headings the criteria relevant to the balancing exercise which had emerged from its case law to date. So it took stock and tried to formulate into 6 broad headings the key factors in the balancing exercise. Paragraph 93 at page 759 is of some importance because in our case, because the Strasbourg court emphasized as one of the factors the method of obtaining the information and its veracity. That is a factor which can operate for or against the media in the balancing exercise. Here, of course, we will be so I won't read it to you, it's familiar stuff. The Article 10 right is enhanced if the reporting on public interest issues is reporting in good faith on an accurate factual basis and providing reliable and precise information in accordance with the ethics of journalism. The ethics of journalism, of course, requiring balance when you attack somebody's reputation. Here, of course, we will be reporting in good faith, and we'll be reporting the facts about what happened and what emerged in open court in the criminal proceedings, including, in his favour, the fact that the appellant was de-arrested. 94, the first 3 lines are also important regarding the way the report is published and how the person is represented in it. Here, we will be identifying the presumption of innocence by reference to the outcome of the proceedings against the investigation into PNM. It will be fair and accurate reporting. 96, the court is now applying the facts to the criteria it has identified, and in his written case and in argument, my learned friend took you to this passage, first 5 lines and the last 5 lines. So I won't read them again. These are the passages about the presumption of innocence. But there is absolutely nothing new in Article 10 law in relation to those principles. The Strasbourg court has referred for many years, in the defamation cases in particular, but also in contempt cases, and now here in privacy, to the importance of press reporting respecting the presumption of innocence. It is a cardinal principle under Article 10 if you want to defend the journalism against a challenge. Unless, of course, in defamation, the journalist is prepared to take on the burden of proving the truth of an allegation of guilt. So our reporting, again, will do that. But there's nothing new there. He also relies on the last 5 lines of 96. The interest will vary in degree. This is the interest in criminal proceedings. However, it may evolve, as it may evolve during the course of the proceedings from the time of the arrest, according to a number of different factors, etc. There will be a varying public interest in it. Well, what is important is that this does not say the fact of an arrest cannot be a matter of public interest. Quite the contrary. What it's saying is it can be a matter of public interest, but it's simply making clear that the circumstances of the case will affect the extent to which this will be so. And as I say, the reason, more importantly, why none of this helps the appellant is the outcome on the facts, which you get at paragraphs 100 and 101 on page 763. Sorry, 109, 110 and 111 on 763. The Strasbourg court found the injunctions preventing the republication of the first article was a violation of the Article 10 right. In reaching this finding, please note again, by going back to paragraph 108, shortly before, that the articles, this is under the heading Content, Form and Consequences of the Impugned Articles, 5 lines down, court observes the first article merely related to X's arrest, the information obtained from W and the legal assessment of the seriousness of the offence by a legal expert. The articles, then it deals with the second article, and it goes on to say, the articles did not therefore reveal details about X's private life, but mainly concerned the circumstances of and events following his arrest. Now, again, the court is not saying the articles don't engage Article 8, but they're saying what's being reported is not something about his private and family life. So the same point we see in Ries, the same point we see in The Guardian, and the point we say that applies here. So this remains the leading Strasbourg authority on the balancing exercise in the context of an article about an arrest. It shows no trend toward restricting media rights to report arrests, criminal proceedings generally, in a way which would require any amendment to our common law. The third general heading the appellant relies on is the Canadian cases and the approach adopted in those. I can take this relatively shortly. The Canadian Charter of Rights and Freedoms is a constitutional provision, forms the first part of the 1982 Constitution Act. The approach under the Charter to reporting publication bans, as they're known in Canada, which are orders prohibiting reporting of court proceedings, is well established and well known. It's known as the Dagenais-Mentuk test after the 2 Canadian Supreme Court cases in which the test was identified and refined. And it is summarized in the judgment of Mr. Justice Sharp, Justice of Appeal, in the Cornwall Public Inquiry case at 1006. This is a decision of the Court of Appeal in Ontario. It's not necessary for me to read the test, but simply to observe. This is the standard formulation repeated by a judge, Mr. Justice Fish, in another Ontario case. I think it has 2 limbs to it. The first limb is a necessity threshold. It's called the necessity part of the test. So the order has to be necessary. And the second limb is a form of balancing exercise of the sort we're familiar with under Article 8 and Article 10. This test has to be applied to the facts in any case, by the first instance judge, in any case where there is an application for a reporting ban. The court should also look, if you would, at paragraph 42 in this judgment, the Cornwall Public Inquiry case, which we say sets out the law correctly. This was a case, the Cornwall case was a case in which a public inquiry had refused to anonymise, and there was an appeal to the Court of Appeal. It was a sexual exploitation public inquiry. The court says in the middle of that paragraph, these cases reinforce the presumption of openness upon which McIntyre rests and posit a flexible and contextual balancing exercise that is to be applied in a non-mechanistic fashion with reference to the particular interests at stake. While protection of the reputation of innocent persons is a highly significant factor to be weighed in that balance, it does not automatically trump the public interest in an open hearing and the right to freedom of expression, just as the public interest in an open hearing and the right to freedom of expression do not automatically trump the protection of innocence. As the Commissioner properly found, all the pertinent rights and interests must be weighed in the balance. And with respect, we say that's no different to the way we do it here. It was recognised at the outset, indeed in Dagonet itself, that preventing damage to the administration of justice could require protection of privacy interests before the court. And you can see this if you turn to page 1033, paragraph 25 in the judgment of Mr. Justice Adams in the Newfoundland case that we looked at yesterday in the matter of an unnamed person. Because following the short form of the Dagonet-Mentuk test, which we're familiar with and looked with a moment ago, there has been clarification given by the Supreme Court. And this is a passage in Dagonet, in the Chief Justice Lamer's judgment in Dagonet, where he goes on and says, paragraph 25, rather than simply focusing on the fact that bans always limit freedom of expression and usually aim to protect the right to a fair trial of the accused, it should be recognized that ordering bans may, and amongst the things he includes, is preserve the privacy of individuals involved in the criminal process, for example, the accused and his or her family, as well as the victims and the witnesses and their families. So privacy is recognized as an interest that can weigh in the Dagonet-Mentuk test.
Yeah.
Can I just mention, without going to it, MEH versus Williams in the bundle? It's again an Ontario Court of Appeal case, and it's an example of a case where the privacy rights asserted by someone subject to a police investigation were regarded as insufficient on the facts to justify a publication ban. The cases cited by the appellant deal with a number of different open justice reporting issues. Some, such as in the matter of R versus Henry, have very unusual facts, which you'll see if you read the cases. Some are not even Dagonet-Mentuk cases. For example, Briggs, which you were taken to yesterday, was a case against the state about retention of private material, DNA material. My learned friend has cherry-picked from these cases dicta, abstract statements of principle by the judges concerned that support his case. They may well have been very appropriate statements of principle on the facts of that case in the balancing exercise. But we could do the same by picking strong statements regarding the importance of open justice. None of this assists in understanding the essence of the law in Canada in this area, which is the Dagonet-Mentuk test. Beyond that, it's fact. Significantly, none of the Canadian cases involve an application for an injunction, as here, after public criminal proceedings in which the person seeking the injunction has been identified and discussed. Still less a case of that type where such an injunction was granted. So there's no suggestion anywhere in the cases that PNM would get his injunction in Canada. Moreover, our law, Ries, is probably more favourable regarding privacy. This is because the threshold test under Dagonet-Mentuk is necessity for the order before you get to any sort of balancing, whereas the applicant here could invoke the reasonable expectation of privacy or a different threshold in this injunction application, but it would be an easier threshold to cross than the first stage of the Dagonet-Mentuk test. And would be harder to get to the balancing exercise. We included in our materials New Zealand and Australian materials simply to show that there is no single Commonwealth approach to these issues. Under Australian law, for example, a Ries privacy injunction is not possible at all. Finally, my learned friend refers to the policy material, which he took you to yesterday. Again, I can deal with this relatively shortly. I do want to make some comments, though, that may be of importance. The essential sequence was that Lord Justice Leveson included in paragraph 2.39 of his report the comments that you were taken to yesterday. And that led to the College of Policing having been set up the following year, in 2013, producing the guidance at page 443 that you were also taken to yesterday, and I won't go back to that. Save to note that at page 443, paragraph 3.41, the College of Policing recognises that information about an investigation and arrest can be known to journalists for a variety of reasons, not simply because it is passed on or publicised by the police force conducting the investigation. This document is guidance about how police forces should determine when to release information about suspects and arrestees. The question of whether a court should prevent a media organisation reporting such information once it is in possession of the media organisation is a very different one. These are my observations, and they may be simplistic and obvious, but they need to be said. There may be public aspects to the involvement of the person as a suspect or an arrestee, most obviously, but not solely, where the offence or arrest is in public and the person's identity is known to those present. Secondly, the information may be revealed to the press by other suspects or their legal representatives or the person's employers, or note by the complainant, including in a sex offence allegation case, who has a right to be informed as the complainant of police developments in the investigation and is not bound to keep that information confidential. So a complainant can speak to the press about who he or she has made the allegation against and what is happening in the proceedings, and so on. So the journalist doesn't just get information from the police, which is what the guidance is dealing with. There may be other confidential or open journalistic sources.
Yes, I see.
Or it may emerge in open court proceedings, as in this case. As the authorities referred to above indicated, the approach to whether the court should injunct such information in the hands of the press, wanting to publish it in the public interest, is much, much more complex than the issue being tackled in this guidance, which is what senior police officers should say to police forces about when they should release that information. And it's much more complex because at this stage, the Article 10 rights of the press and the public are engaged. The law relating to this cannot be determined by reference to police internal guidance about disclosure by police forces of information by them. And so, when Mr. Barker said yesterday in oral submissions, I'm sure it was a slip, that we, on our side, agree that an arrest is a private matter, this is quite wrong. Whether the press should be free to publish information that it has about an arrest or an investigation is an acutely fact-sensitive issue. And it's not difficult to postulate a case, for example, like those under discussion before Christmas. Suppose a football coach at a Premiership football club is arrested for offences against minors who he's been coaching, maybe historical offences and so forth. That will come to the attention of the press. Is somebody saying the press are not entitled to report that in the public interest, given the job of the person concerned and the public interest in those issues? You simply can't have blanket rules in this area. Everything depends on the facts. The other documents referred to with respect are also, if I can put it this way, shooting at different targets to the one the court is being asked to shoot at in this case, for similar, no, not exactly the same reasons. In relation to the Law Commission consultation, document and the responses of the ICO and the judges, Lord Justice Tracy and Mr. Justice Tugendhat, if you read those documents, you'll see that what happened in 2013 was that the Law Commission put out a consultation paper suggesting that the opposite presumption should apply, namely that police forces generally should release information about those they have arrested. And the point of those passages in the responses to the consultation by the ICO and the judiciary was that from their perspective as judges involved with the administration of justice or the ICO concerned with data protection, they were not happy about the proposal being put forward for consultation, that the thing should operate the other way round from the way suggested in the College of Policing guidance. So context is everything, but again, they don't bear on the issue the court has to decide, which is about press rights to report arrests and police investigations. And the Enriquez report was concerned actually with the practice in Midland of not releasing the name, but releasing identifying details about the suspect at key points in the investigation, a search or an interview. And the details concerned were enabling the press to identify who was involved and therefore to report. That's what the report was about. It was about that practice. But note, recommendation 10 at page 1242 in Enriquez was actually for the need for a statute preventing anonymity prior to arrest. So the Enriquez statute wouldn't have helped this appellant. And in any event, such a statute, if Parliament were to enact it, would presumably contain provisions addressing the right of the press to report in this area, including in open court proceedings. So we say, drawing the threads together, that the approach in the cases relied on by the Court of Appeal, Ries and The Guardian, is correct as a legal approach. They do allow a person's privacy interest to prevail in an injunction case, in an appropriate case, including a suspect or arrestee. They just did not prevail on the facts in this case. Finally, my last heading in the second part of our case, it is a matter for Parliament to create a further exception to the open justice rule of a sort of category type, whether it's for suspects in sex cases or for suspects more generally, whether referred to in the criminal courts or whether reference is made outside of court. Looking at the facts of this case,
Well, that comes back to what you say Lord Steyn said in Ries.
yes,
Yes, I understand.
using the Ries jurisdiction in a case like this, I just want to add this comment, it's very, very important, is problematic. I come back to what I said about the shape of the case. It's a judge in the High Court assessing what the press who have been in a Crown Court can report, or in a Ries-type case in advance, before the criminal trial has taken place. Here, unusually, after the criminal trial has taken place. The best person to assess whether parts of a criminal trial should be suppressed, i.e. withheld from public gaze, or subject to a permanent reporting ban, is the judge trying the case. Put differently, to answer the Lord Roger question, the person who should say whether there's sufficient public interest to justify publication of the report of the proceedings, naming the person, is the judge who is trying the proceedings before him or her. It is unsatisfactory for a High Court judge at one remove to try and identify the parts of the trial that should be subject to an injunction or not, applying that test. It is difficult enough in advance of the trial, in the way we see in Ries. It is almost impossible after the trial, as here. The judge who has heard the whole case can assess which parts of the evidence should be suppressed or reporting of them prohibited, knowing all the evidence and everything that has happened at the trial. Very difficult for a High Court judge to do that. But, and this is the key point, Parliament has conspicuously chosen not to give such a jurisdiction to to the judges who try our criminal cases in the criminal courts. There is only the narrower possibility of withholding in the exercise of the inherent jurisdiction certain information from public gaze and the consequential direction under Section 11 that we saw in the BBC case. And that power was not exercised here. His Honour Judge Rooke spent a lot of time considering Section 4.2, but did not anonymise PNM at the trial and did not make a consequential Section 11 order. In all submissions, it was suggested that the courts cannot know or control any reporting about PNM that may follow our court reports, the ones that are in issue. This is to misunderstand the position, and I come back to where I started yesterday. The law constrains what can be reported in that situation. This would have to be reporting protected by Section 14 of the Defamation Act, 1996, any consequential reporting, or PNM could sue in libel. That's how our law works. If it went beyond court reporting, he could injunct in privacy without open justice issues arising, because it wouldn't be a pure court report. And if he were rearrested, the law of contempt would kick in and restrict what the press can report. So the law does control very strongly what might be published in relation to PNM after our court reports. And I want to make one final point to finish, and it is this. We tend to look at these issues now in this jurisdiction because our developing law of privacy has enabled the prior restraint jurisdiction to develop from the point of view of prior restraint injunctions. And that's what this case is about, and it's what Ries is about. So that's perhaps unsurprising. But the court does need to consider the position if the appellant's premise is correct and there had been no Section 4.2 proceedings. So we would have reported what he says is private information, misusing it contemporaneously as the trial progressed. And there is another remedy. A person in that position, relying on this cause of action, can sue in damages. You haven't prevented the publication by prior restraint. Such a law would chill court reporting dramatically, especially in the criminal courts. Reporters would be at risk of self-censoring parts of their contemporaneous reporting of a criminal trial to avoid a risk of later being accused by a person and his lawyer of misusing private information and being sued in damages and having to litigate and justify their report on the basis of the balancing test. And in the bundle at page 943, is a judgment of the US Supreme Court in a case called Cox Broadcasting. It's Mr. Justice White speaking for the court. And as far as this spectre is concerned, I just want to read what he says because it's difficult to improve on it. In America, the jurisdiction does not allow the prior restraint injunction. So this television reporter had reported material that came out in open court proceedings on a television report and been sued later in privacy for reporting those parts of the open court proceedings for damages. And what Mr. Justice White said was, in the bottom paragraph, "We are reluctant to embark on a course that would make public records generally available to the media, but forbid their publication if offensive to the sensibilities of the supposed reasonable man. Such a rule would make it very difficult for the media to inform citizens about the public business and yet stay within the law. The rule would invite timidity and self-censorship and very likely lead to the suppression of many items that would otherwise be published and should be made available to the public. At the very least, the First and 14th Amendments will not allow exposing the press to liability for truthfully publishing information released to the public in official court records. If there are privacy interests to be protected in judicial proceedings, the states must respond by means which avoid public documentation or other exposure of private information. The political institutions must weigh the interest in privacy with the interest of the public to know and of the press to publish. Once true information is disclosed, public court documents open to public inspection, the press cannot be sanctioned for publishing it. In this instance, as in others, reliance must rest upon the judgment of those who decide what to publish and broadcast. Those are our submissions.
Thank you very much indeed. Mr. Wolanski. Mr. Barker.
Lord, I'll comfortably finish before the shortage of, and I hope so.
Before 5 to
That's
1.
always
Before 5 to 1.
It's always a comfort to know, I hope. Can I deal with the reply topics and casting our minds back to yesterday? I'll start with the engagement of Article 8. The respondents have always accepted that Article 8 is engaged, and one need don't do no more than remember my Lord Sumption's intervention, reminding a learned friend about paragraph 14 of the Court of Appeal judgment at page 107. One could also look at the respondents' first instance skeleton argument at paragraph 20, that's at page 171, where it is said in terms, it is accepted that the appellant's Article 8 rights are engaged. It's also worth remembering, for what it's worth, that the respondents did not seek to raise any dispute in this regard in the agreed statements and facts and issues for the purposes of this appeal, and one can look at that at page 40. My learned friend falls into a fundamental trap in the way he's put his submissions in this regard. The issue is not whether the information itself relates to private and family life. The issue is whether the information will have an impact upon the applicant's private and family life.
Put to him by some of my colleagues. Yeah.
Yes, and that is the key distinction that we say that he fails to observe. You'll recall at the opening of my learned friend's submissions, and he's almost come back to it today by referring to the fair and accurate reporting and so forth. He mentioned and almost expected credit for the fact that the two journalists, when they sent the May 2013 emails, invited the appellant to make comments before the stories were published. Now, this only serves to underline the point I made yesterday, that what was contemplated then was a far-reaching and potentially seriously defamatory story, which would be needed to be defended in the course of libel proceedings. Put another way, there's no need to be concerned about libel risks if all you were at that stage proposing to publish is a fair and accurate court report. And that brings me to the shifting grounds of what it is apparently the respondents wish to publish. You'll recall my taking you to the last paragraph of the respondent's case, and it seems that the grounds have shifted. First of all, we had the May stories that I've just referred to, far-reaching, wider stories, going well beyond anything covered in the criminal trial. We then moved, secondly, to a court report of the Section 4.2 proceedings without more. We then appeared to move to a court report of the Section 4.2 proceedings plus honest opinion thereon. And then in the course of this appeal, before this court, we now seem to be moving to a report of aspects not only of the Section 4.2 orders, and you recall it was squarely put in the various extracts I took your ladyship to, talking about what they're wanting to report being arguments and rulings concerning the imposition and discharge of the maintenance and discharge of the Section 4.2 order. What we now appear to be contemplating is a reversion to reporting aspects of evidence in the criminal trial itself. Now, we say this is the first time before this court that it's been suggested that the respondents wish to report more of the criminal trial. And we respectfully adopt the well-taken question put by my Lord Kerr, in querying, well, what is the ambit, the precise ambit of what the proposed report would contain? And my learned friend made what appeared to be a concession in answer by saying, well, there isn't an ambit beyond the Section 4.2 report, although it would seem there was an attempt to reach back insofar as the Section 4.2 report itself would touch upon material given during the trial. Now, we would say there's an element in this sort of parrying that smacks of a self-serving recasting of what the respondents wish to publish for the purposes of this appeal. And this is the Trojan horse argument again. The obvious reason for doing this is firstly to bolster their recourse to the open justice principle, and of course that then opens the door to their reliance on the case law concerning the reporting of a criminal trial. And I underline the word trial, which is what Guardian News and Media and the Ries cases were concerned with. Now, we say plainly different considerations must apply to the reporting of an ancillary Section 4.2 proceeding than apply to the reporting of the actual criminal trial itself, which is what those cases, Guardian and Ries, were concerned with. The rationale of the Lord Rogers' what's in a name point, we say, is in part to ensure that the public can properly understand what is going on, including, importantly, in the course of a criminal trial, particularly one such as Jamil, where there were many protagonists and many defendants. An important point is including who the protagonists are. But when you're dealing with Section 4.2 proceedings, these tend to be self-contained, they concern short, focused arguments, and in this particular case, related only to one person as the subject. In such a case, such as this one, there's no risk of any confusion in the mind's eye of the public. Perhaps taking my cue from the intervention made by my Lord Kerr, we would endorse the thinking that seemed to underpin the intervention. The public can perfectly well understand what went on in the Section 4.2 proceedings by knowing simply that the person involved is someone who was firstly arrested, secondly who may or may not be charged, and thirdly whose right to a fair trial needed to be safeguarded in the meantime, because that was what the Section 4.2 proceedings were concerned with. Now, with regard to the proposed reports as described in the evidence I took you to, and your lordships will have seen in the evidence put forward by the journalists on behalf of the respondents, what is essentially a layman's law report of that kind, that's to say, reviewing the arguments and rulings about the imposition, maintenance and discharge of the order, a report of that kind simply does not need the identification of the subject of the order, and certainly not, we say, to the point where any such ostensible need is such as to outweigh this appellant's Article 8 rights to private and family life. Now, before leaving this topic, I'll just make these observations. This apparent new departure in the way that the Section 4.2 report is now going to reach back or be used as a springboard to reach into evidence at the trial illustrates that you simply cannot, as a court, and no court can rely on, what assurances are given through counsel at trial as to the ambit and nature of a proposed report. I stress again a point I made in opening. This appellant is not seeking to prevent the publication of court reports. What he's seeking to prevent is the publication of the specific private information in question, regardless of the guise of the proposed publication. And I stress again, once that information is published and enters the public domain, it's then open season, and there will be nothing that this appellant can do to prevent further and potentially more wide-reaching breaches of his Article 8 rights to private and family life. Can I then turn to what my learned friend called the category exception, I think if I put it in inverted commas. Now, we respectfully confirm Lord Kerr's understanding of what my submissions were yesterday. To be clear, we do not seek a category exemption. The 5 areas that I identified are simply those factors which we argue in an inappropriate case should be afforded greater significance than has been the case hitherto. I think I'm now paraphrasing Lord Kerr's paraphrase of my submissions, but that is absolutely key to bear in mind. We are not asking for an either-or, a blanket exemption of the kind, as my friend says, it would require Parliament to bring in. Or we're simply introducing the factors that should be given more attention than we say they've been given in the past. As in any privacy case, This will require, a much-used phrase, an intense focus on the facts. And precisely how heavily those factors should weigh in the balance will still depend upon the individual facts of any given case. And one has to bear in mind that the extraordinary facts of this case, which, as we saw yesterday, resonate with the sort of facts in some of the Canadian cases we looked at yesterday, are exceptional. These are always going to be exceptional cases. It's not going to be the run-of-the-mill case, an Axel Springer case, where one has somebody who's simply been arrested in public at a public beer festival or pop festival, or whatever it may be. We're dealing with very exceptional facts, dealing with very exceptional offences that carry particular opprobrium in the public mind. One of the points...
So what do you say is exceptional?
Well, the fact is, the nature of the offences, and
these offences are rather less exceptional than one would have hoped.
I'm sorry, I lost...
Such offences are rather less exceptional than one would hope.
Yes, in terms of their frequency, that is undoubtedly true, but in terms of their gravity, firstly, and secondly, the reviling in which people are held who are brought anywhere near them are exceptional. I can't remember the exact phrase in one of the Canadian, but I think it was something along the lines of the most reviled in society. It's difficult to imagine few criminal offences that bring people into greater, to use a phrase from the old libel, or into public hatred and contempt. It is in a uniquely short canon of offences that excite public outrage. And one has to look at it, and that's a very important component. One can
So
see...
you're saying that it's the character of the offence, the public's reaction to the offence, that makes these cases exceptional?
Well, it can do. It again depends on the nature of the facts. It depends...
So the trouble is, when people say this is a very exceptional case, they tend to mean it's a very rare case too, so you don't have to worry too much. And that's why I asked you exactly what you say is exceptional about this case.
Yes, well, it's certainly the nature of the offence, but also the exceptional aspect of this particular case is the sidewind by which the appellant was brought into the focus of the criminal proceedings. It was only by a sidewind and collaterally in the Section 4.2 proceedings.
There are many cases involving less serious allegations than sexual abuse of children,
yes,
which nevertheless have the potential to damage the interests of children who are aware of the proceedings involving in some way a parent, and damage the parent's relations with his children. So that in the particular context with which we're concerned, even if one concluded that sexual abuse cases are exceptional, the cases which would engage the principle on which you rely are not particularly exceptional, are they?
Well, again, it would depend on the circumstances in which the person seeking the court's assistance found himself before the court. I agree.
Potentially, surely it would affect any case in which an allegation is made which damages a person's relations with his family or causes serious distress to children.
Yes, well, certainly as a proposition, I wouldn't dispute that outcome is possible in every case. The only issue is whether the court should intervene. And to take perhaps an example, if one were dealing with, let us say, a choir master who simply touched the behind of a choir boy in a cassock, well, obviously, a choir boy under the cassock, it would be disagreeable, and it would have all the consequences my lord puts to me, but it would not attract perhaps the same grotesque opprobrium as somebody accused of being involved in an exploitative paedophile ring in a major English city of the kind that was dealt with in this case and various others. It's a question of degree. Now, it really does depend on the facts of the case, whether the court says, well, it's sufficiently grave circumstantially to warrant the court intervening and protecting the individual, no matter what the consequences. Now, the example I've just given, a court could say, well, I appreciate it'll cause reputational damage, but not such as the degree that the court should intervene.
When dealing with the exceptionality or otherwise of these facts, do you put the de-arrest into the mix or not?
Do I put the...
De-arrest.
The de-arrest is certainly important, and that's another factor I would have prayed in aid. I mean, in terms of, it brings in aid, I'll come on to the category exceptions individually in a moment again, the context of Mr. Justice Tugendhat's judgment. But it's an important factor because it feeds into the presumption of innocence element. There is a world of difference between somebody who's been charged. I went through this yesterday, I don't want to repeat it again. The other factors come into the pot as well as presumption of innocence the further you go down the criminal proceedings line. If you get through to the point where you have an actual accused, obviously the presumption of innocence element is much reduced compared with somebody in the position of this appellant, who is simply somebody who was arrested for a time and then was de-arrested. And a more extreme example might be somebody who was de-arrested because of mistaken identity and is then released after, say, a few weeks. Again, the presumption of innocence in that case would be correspondingly stronger. But we do say that in answer to my Lord's question, that the de-arrest factor is an important one on the facts of this case. It never got beyond a policeman, the police arresting him and then deciding there was no basis on which to proceed and then to de-arresting him, to use that term. I think that's a term that's used by criminal practitioners. I'm not sure it has any, it's not a term of art. But certainly that is, we say, an important factor. Can I then turn to the talk, as we're on the subject of the 5 categories, can I then turn to the 5 categories themselves, having established that we're not asking them to be set up as canonical exceptions to be applied in every case. I think it was my Lord Reid who put to me, well, how, having enumerated, these are all dealt with in the case, but having enumerated those 5 factors when called to do so, how do I relate those back to Mr. Justice Tugendhat's judgment, which is one of the criticisms made of us by my learned friend, is to say, well, you've got to show how it is you say the judge went wrong, to such a degree that the Court of Appeal should have intervened. Well, can I take very briefly the 5 factors in turn? With respect to A, presumption of innocence, and B, stigma, these were expressly relied upon and brought to the judge's attention in argument. I won't go there, but can I just refer you to where they were raised? Yep. It's paragraphs 40 to 42 of our skeleton at first instance. That's page 156. Yep. And it'll become apparent, your lordships will have picked up, there's no evaluation of these considerations in the judgment. Yes. With respect to the third, category C, that's the one about suspicion even leading to the taint of guilt in some people's eyes. I dealt with that yesterday, I hope, in answer to my Lord Reid's question. And I think my Lord Sumption returned again today to the tensions between section 75 paragraph 75 and paragraph 77. And what we respectfully agree is the error of law consisted in treating res as somehow containing a pronouncement as to a principle of law, which my learned friend, I think, agrees is not there. There is no presumption of law. There's no legal canon that says you must treat in every case, proceed on the footing that all members of the public can distinguish between mere suspicion and guilt. With respect to the fourth category, that's that accusations of sexual offences are especially apt to cause irreparable harm, we say this, that while at paragraph 75 of his judgment, as we've seen, Mr. Justice Tugendhat accepted the risk of some harm, we say that he failed to give sufficient weight to the fact that such harm was likely to be irreparable. It's not, as my learned friend was suggesting in his closing submission, something that can be remedied with an award of damages and some sort of financial vindication after the event, as though it were a simple libel action. Once the cat's out of the bag and he has been vilified and is exposed to the risks that the judge seemed to accept were there, that damage is irreparable. Yep. Finally, the fifth category, that's the growing recognition. If you look at the judgment, all this is simply left out of account. It was all raised before the judge, I mean, including, ironically, the judicial response to the Law Commission report that he and Lord Justice Tracy wrote. But as we say, that was simply just not in the mix so far as Mr. Justice Tugendhat is concerned. Can I then I hope it helps, before I come to deal finally with the foreign authorities, very briefly. My Lord Sumption raised a question as to what was there beyond that which was discussed at trial that remained private or secret. It may assist, and I'll give you, your lordships, the reference, just so you have a feel for what was actually argued in the Section 4.2 proceedings. That can be found in the appellant's skeleton at first instance. And starting, we'll just quickly go there. It's page 160. Your lordship will get a flavour of precisely what sort of information was canvassed during the Section 4.2 proceedings. I'm not going to read all this out, but this sets out some of the discussion that was contained in the skeleton arguments and then developed further in the Section 4.2 proceedings before His Honour Judge Rooke. And I'll take up the narrative at paragraph 54.1 at the bottom of page 160. Paragraph 10 of the first defendant's skeleton argument, dated the 8th of May 2013. The first defendant's counsel made reference in relation to one of C's bail conditions to the first defendant's understanding that the claimant's passport, having been seized after the arrest, had since been returned to him. You then had questioning by leading counsel for the then, now appellant, questioning the source of the information as being a matter that was not in the public domain. There were then further concerns you'll see in relation to a second matter, which I'm not going to read out, which is the second bullet point at 54.3. Yep. And further comment of that sort. Yep. And then over the page, I'll leave it after 54.5, there was a clear call for explanations from the appellant's counsel in the criminal Section 4.2 argument, an explanation from the Thames Valley Police, or how it was that this information had come about. So I just raise that to say that that's the sort of information that came to be ventilated in the Section 4.2 proceedings. And for obvious reasons, particularly in relation to the second such matter, it's material that would be damaging. I'll come back to you in a minute. Can I then just quickly deal with the other authorities?
Yes, indeed.
Yeah, very quickly. Australia I can deal with in a line. I think I've dealt with it already.
They don't have a privacy.
They don't have a privacy right, so its value as a legal comparator is useless. So far as the US is concerned, that really is, their law has now evolved to the point where it's so far removed from common law experience, as we understand it, as to be of no value. First Amendment considerations, extreme aversion to pre-publication restraint, renders it another legal planet. For instance, there are no comparable laws of contempt in the US to prevent pre-trial prejudice. The only one I'm just going to quickly refer to, and it will be my last observation, is in relation to New Zealand. If I can ask your lordships to look at the New Zealand statute that my learned friends relied on. That's in volume 2 for those following in paper terms. It's tab 34, it's page
1196, yeah.
Yes, 1196 and 97. There are two provisions you'll see. Section 200 of the 2011 Act allows the court to suppress the identity of a defendant. And 2A you'll see where the publication will cause extreme hardship. The test you'll see for other parties, that's non-defendants, over the page at 202. It's the test there is only if it causes undue hardship. Yes. So that's an important distinction. And if I can just, the last authority we'll look at, it's a very short passage. It's a case called Beacon Media Group. And that's tab 19. It starts at page 881 of the electronic bundle. First instance decision of the New Zealand High Court. And it's really a definition of undue hardship. Paragraph 22 on page 887 is the Court of Appeal recognising little innocent family members will almost inevitably suffer anguish when an offender is convicted of a serious crime. However, such normal consequences will rarely be sufficient to displace the public interest in the open reporting of court proceedings. The public interest in open justice and freedom of expression will only yield in the case of a defendant in criminal proceedings, where it can be shown that the harm likely to be suffered as a result of publication is extreme or excessive. By contrast, victims, witnesses and others connected with the proceedings of the or the defendant. You'd only show that they are likely to suffer undue hardship as a result of publication of their details in connection with the proceedings. And then this, which we say is perhaps of assistance. Undue hardship is therefore something more than the hardship that would normally attend publicity surrounding criminal proceedings, but less than extreme hardship. So we say there is perhaps some assistance for the appellant, ironically, to be gained from that analysis.
Yeah,
I think if the Lordships will bear with me one moment.
of course.
Perhaps I should, yes, I'm grateful to my learned friend Ms. Reddy. It's a point perhaps worth making, though it's perhaps obvious. Even if there were, your Lordships were to find, or one can argue that there is at present a legal presumption that persons understand the difference between suspicion and guilt, then this would be the opportunity for this court to consider ruling, and we would invite you to do so, that any such presumption or any such understanding is no longer good law. At the very least, it would be a welcome opportunity to clarify that what was said by Lord Roger in the Guardian case should not so be seen in future.
It's really a question of fact, though, isn't it, not law?
Well, yes, in some respects, one would. It's a question of fact, exactly. It's one of the factors, the 5 factors we bring into the pot, that the court shouldn't take such a prescriptive view, that there will always be people who, depending on the nature of the offence, are likely to see the taint of guilt more readily than in other cases. But I agree, I accept your Lordship's prompt that it is perhaps more fact-sensitive than a prescriptive rule would suggest. Lords, that well within budget time is all we have to say, unless I can assist further.
The quality that matters, not quantity, Mr. Ross.
Can I just ask you for
Yes.
a piece of information? We don't know terribly much about the facts of what actually happened at the trial. There's a certain amount of information in the draft judgment. I don't think it's actually been handed down of His Honour Judge Rook.
Yes.
But as I understand it, there was mention of the appellant in the opening of Crown Counsel. Is that right?
I'm not sure that's right. As my understanding, again, I'm at one remove. Mr. Walensky may know more because he attended some of the hearings. My understanding is the only mention made of the full name of the appellant was when a police officer gave evidence and simply referred to a person having that name. He didn't, having been subjected to an identification procedure. I'll be corrected if I'm wrong, because I don't...
Perhaps Mr. Wolanski can tell us.
Yes.
The appellant's Christian name was referred to in the Crown's opening submissions, and it was that prompted the application for an order under Section 4.2. The appellant's full name was then referred to in evidence from the police officer and was subsequently referred to in submissions to the jury in cross-examination, closing speeches, and in the summing up.
How much in cross-examination in terms of, as far as you remember?
Well, on several occasions.
Is there a transcript?
There isn't a transcript of the trial. What we do have, it's not in the...
No, understood.
But we can certainly provide it, is the skeleton argument prepared by Miss Bennett-Jenkins.
If the skeleton argument gives us the sort of information that Lord Reid has asked for, I think we would like a copy, yes.
I can certainly provide that. And that was prepared by leading counsel for the appellant on the application.
In fairness to both parties, what we'd like, I think, is a copy of that skeleton argument or the relevant extract. And if either party feels that there's further information we should have, simply relating to what was said at the trial, they should let us know. If that could be done in a week?
Yes, I should think so. We've seen all those skeletons before. They should be to hand.
The name was put to more than one witness at the trial.
Certainly to one witness.
Well, we'll see.
You said in cross-examination several times, yes.
We'll see.
And it might be helpful even to know at this stage, was the line being pursued on behalf of the defendants that the appellant was somebody who I don't know, ought to have been investigated further, or ought to be on trial, or had actually perpetrated the crimes of which a defendant was accused, or what?
I think it's fair to say yes, but that should emerge.
So that's yes to what? To which of the...
By the sound of it, you'd rather we saw the note rather than you committed yourself, right?
And I should make clear that the counsel who made the note had a noting brief at the trial.
That's helpful. I hope this can be agreed between the parties. If we need further information or submission as a result of that, we'll ask. And it can be dealt with, I hope, in writing.
Right.
Meanwhile, thank you all very much indeed. Thank you for your all submissions and competing in each case well inside your budget, particularly your reply, Mr. Barker. And thank you also for everyone involved. Thank you also to everyone involved in the written cases, which we found very helpful. Thank you very much indeed. We'll consider this matter and in due course let you know our decision. Court's now adjourned.